Maryland v. Pringle, 2003. Chief Justice Rehnquist delivered the opinion of the court. At 3:16 a.m. on August 7, 1989, a Baltimore County police officer stopped a Nissan Maxima for speeding. There were 3 occupants in the car: Dante Partlow, the driver and owner, respondent Pringle, and front seat passenger, and Otis Smith, a backseat passenger. The officer asked Partlow for his license and registration. When Partlow opened the glove compartment to retrieve the vehicle registration, the officer observed a large amount of rolled-up money in a glove compartment. The officer returned to his patrol car with Partlow's license and registration to check the computer system for outstanding violations. The computer did not reveal any violations. The officer returned to the stopped car, had Partlow get out, and issued him an oral warning. After a second patrol car arrived, the officer asked Partlow if he had any weapons or narcotics in the vehicle. Partlow indicated that he did not. Partlow then consented to a search of the vehicle. The search yielded $763 from the glove compartment and 5 plastic glassine baggies containing cocaine from behind the backseat armrest. When the officer began the search, the armrest was in the upright position, flat against the rear seat. The officer pulled down the armrest and found the drugs, which had been placed between the armrest and the back seat of the car. The officer questioned all 3 men about the ownership of the drugs and money and told them that if no one admitted to ownership of the drugs, he was going to arrest them all. The men offered no information regarding the ownership of the drugs or money. All 3 were placed under arrest and transported to the police station. Later that morning, Pringle gave an oral and written confession in which he acknowledged that the cocaine belonged to him, that he and his friends were going to a party, and that he intended to sell the cocaine or use it for sex. Pringle maintained that the other occupants of the car did not know about the drugs, and they were released. The trial court denied Pringle's motion to suppress his confession as a fruit of an illegal arrest, holding that the officer had probable cause to arrest Pringle. A jury convicted Pringle of possession with intent to distribute cocaine and possession of cocaine. He was sentenced to 10 years incarceration without possibility of parole. Why didn't the professor just tell me this when I asked? There was money in the glove box. To suggest reason for search when no priors found. So that's like the closest thing to their probable cause. I don't know why the teacher didn't just say that. Alright. So the trial court found him convicted him. And denied the motion to suppress. His confession. All right. The Court of Appeals of Maryland, by divided vote, reversed, holding that absent specific facts tending to show Pringle's knowledge and dominion or control over the drugs, and mere finding of cocaine in the back armrest when Pringle was a front seat passenger in the car being driven by its owner is insufficient to establish probable cause for an arrest for possession. So, they reversed. It is uncontested that the present case that the officer, upon recovering the 5 plastic glassine baggies containing suspected cocaine, had probable cause to believe a felony had been committed. The sole question is whether the officer had probable cause to believe that Pringle committed that crime. Probable cause standard is incapable of precise definition or quantification into percentages because it deals with probabilities and depends on the totality of the circumstances. We have stated, however, that the substance of all the definitions of probable cause is a reasonable ground from belief of guilt, and that the belief of guilt must be particularized with respect to the person to be searched or seized. In this case, Pringle was one of 3 men riding in a Nissan Maxima at 3:16 a.m. There was $763 rolled of cash in the glove compartment directly in front of Pringle. 5 plastic lysine baggies of cocaine were behind the backseat armrest and accessible to all 3 men. Upon questioning, the 3 men failed to offer any information with respect to the ownership of the cocaine or the money. We think it entirely reasonable inference from these facts that any or all 3 of the occupants had knowledge of and exercised dominion and control over the cocaine. Thus, a reasonable officer could conclude that there was reasonable cause to believe Pringle committed the crime of possession of cocaine either solely or jointly. Pringle's attempt to characterize this case as a guilt by association case is unavailing. His reliance on Ybarra v. Illinois and United States v. DeVry in 1979 and 48, respectively, is misplaced. In Ybarra, police officers obtained a warrant to search a tavern and its bartender for evidence of possession of a controlled substance. Upon entering the tavern, the officers conducted pat-down searches of the customers present in the tavern, including Ybarra. Inside a cigarette pack retrieved from Ybarra's pocket, an officer found 6 tinfoil packets containing heroin. We stated a person's mere propinquity prop INQUIT propinquity to others independently suspected of criminal activity does not, without more, give rise to probable cause to search that person. Where the standard is probable cause, a search or seizure of a person must be supported by probable cause particularized with respect to that person. The requirement cannot be undercut or avoided by simply pointing to the fact that coincidentally there exists probable cause to search or seize another or to search the premises where the person may happen to be. We held that the search warrant did not permit body searches of all the tavern patrons and that the police could not pat down the patrons for weapons absent individualized suspicion. This case is quite different from Ybarra. Pringle and his 2 companions were in a relatively small automobile, not a public tavern, in Wyoming versus Houghton. We noted that a car passenger, unlike the unwitting, I need to go all over the place for cases. Wyoming. When the case is in Maryland, we noted a car passenger, unlike the unwitting tavern patron in Ybarra, will often be engaged in a common enterprise with the driver and have the same interest in concealing the fruits or the evidence of their wrongdoing. Here we think it was reasonable for the officer to infer a common enterprise among the 3 men. The quantity of drugs and cash in the car indicated the likelihood of drug dealing, an enterprise to which a dealer would be unlikely to admit an innocent person with the potential to furnish evidence against him. In D. Ree, a federal investigator had been told by an informant, Reed, that he was to receive counterfeit gasoline ration coupons from a certain Butita at a particular place. The investigator went to the appointed place and saw Reed, the sole occupant of the rear seat of the car, holding gasoline ration coupons. There were 2 other occupants in the car, Butita in the driver's seat and D. Ree in the front passenger seat. Reed informed the investigator that Butita had given him counterfeit coupons. Thereupon, all 3 men were arrested and searched. After noting that the officers had no information implicating D. Ree and no information pointing to D. Ree's possession of coupons, unless presence in the car warranted that inference, we concluded that the officer lacked probable cause to believe that D. Ree was involved in the crime. We said any inference that anyone on the scene of a crime is party to it must disappear if the government informer singles out the guilty person. No such singling out occurred in this case. None of the 3 men provided information with respect to the ownership of the cocaine or money. We hold that the officer has probable cause to believe that Pringle had committed a crime of possession of a controlled substance. Pringle's arrest, therefore, did not contravene the 4th and 14th Amendment. Accordingly, a judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. So reversing the appeal court, and I'm just going to reread what I just read. We said, and this is D. We said any inference that anyone on the scene of a crime is a party to it must disappear if the government informer singles out this guilty person. So, this was a case law holding. Gonna just roll right into. No, I'm not. I'm gonna end this recording and start a new section.